We've got ourselves a serious shakeup in the fight over pistol braces, and the fallout could change the landscape for every gun owner in the country. Instead of starting with dry court filings, let's talk about what this means for you and me. If you've ever shouldered an AR pistol with a brace, you know exactly why the ATF's rule mattered. Overnight, millions of folks were told their legal firearms were now short-barreled rifles, subject to NFA restrictions. That's not just red tape. That's federal prison time if you get it wrong. Now here's the twist. The Trump Department of Justice just pulled back the government's appeal in one of the biggest lawsuits against the brace rule. That move doesn't just close the book on one case. It signals a chain reaction across multiple courts. The ATF's pistol brace rule, which has already been slapped down more than once, is hanging by a thread. And if you think this is the end of the story, buckle up. Because the way these cases are being handled now will determine whether future administrations can recycle the same rule under a different wrapper. So today, we're breaking it down. Why this fight isn't just about one accessory, but about the balance of power between the people, the courts, and federal agencies that keep pushing the line. Here's what most people aren't hearing in the headlines. Yes, the brace rule is being torn down, but the way it's happening could set us up for trouble down the road. Right now, folks are cheering because the ATF took a major loss, and the Trump DOJ decided to walk away from the government's appeal. That's a huge short-term win. It means gun owners don't have to scramble to register millions of firearms, pay hundreds in tax stamps, or risk federal prison just for shouldering a pistol. But here's the catch. This victory was built on procedure, not on principle. Judge O'Connor, the federal judge who first smacked down the brace rule, didn't base his ruling on the Second Amendment. He didn't say that owning a brace is constitutionally protected. What he said was simple. The ATF broke the rules when it wrote the law. They published one version with a point-based worksheet, then swapped it out at the last minute for a different final rule. Under the Administrative Procedures Act, that's a big no-go. It's like a referee changing the rules in the middle of the game. That's why the judge vacated it nationwide. Now, don't get me wrong. That's a powerful victory in the moment. But think about what it means long-term. If another administration comes along, all they need to do is fix the process. They can propose the same restrictive rule. This time, keep the worksheet consistent from draft to final. And they'd argue it passes the APA test. In other words, we could be fighting this same battle all over again in just a few years. And the scary part? There would be no Second Amendment precedent on the books to stop them. That's the part that makes gun rights attorneys nervous. We've seen this movie before. Agencies push the limits, courts slap them back on a technicality. But because no constitutional ruling was made, the agency just tightens its paperwork and tries again. It's legal whack-a-mole, and gun owners are the ones caught in the middle. So yes, the Trump DOJ's decision to concede the appeal feels like a knockout punch, but it's more like a standing 8 count. We get to catch our breath. We get a round of relief. But unless the Second Amendment itself is the reason these rules are struck down, the fight isn't finished. And that's the long-game problem nobody should ignore. Let's talk about how this all played out in the courts, because that's where the real domino effect started. The case that lit the fuse was Mock v. Garland in the Fifth Circuit. Judge O'Connor didn't just pause enforcement of the brace rule, he vacated it nationwide. That means his decision applied coast to coast, not just to the plaintiffs in the case. It was one of the first times we saw the entire rule wiped clean off the books. Now, normally, the government would fight that tooth and nail. And under Biden, they did. The DOJ filed an appeal, tried to get the Fifth Circuit to put O'Connor's ruling on ice and keep the rule alive while the case dragged on. But when Trump's DOJ came in, they took a hard turn. Instead of pushing the appeal, they pulled out. That's not just unusual, that's rare. The Department of Justice almost never concedes like that. And by doing so, they let O'Connor's nationwide vacatur stand in full force. The government walked away, and gun owners walked away with a win. But here's where it gets even more interesting. The ripple effect hit the Eighth Circuit almost immediately. Over there, you've got the Frack Wiesen ATF lawsuit. That's not just one company and a couple of individuals, it's SB Tactical, the company that invented the modern brace, plus a coalition of more than 25 states. Think about that. Over half the country's attorneys general were lined up against the ATF on this issue. That case had been sitting on the sidelines, waiting to see how Mock played out. And the minute the Trump DOJ backed off in the Fifth, the parties in the Eighth filed notice with the court saying they were ready to start settlement talks. And that wasn't the only fight. Gun Owners of America, Firearms Policy Coalition, and the Second Amendment Foundation all had lawsuits cooking in different courts. Each one brought their own members under the umbrella of injunctions, shielding them from prosecution while the cases moved forward. Even before O'Connor's vacatur, gun owners connected with those groups already had protection. Layer those cases together, and you've got the ATF being boxed in on every side. Here's the key point. The ATF wasn't losing just once. They were losing again and again across multiple jurisdictions, with multiple judges pointing out flaws in the rule. By the time the Trump DOJ pulled the appeal, the ATF wasn't just bleeding, they were cornered. And in the legal world, once you've got momentum like that, other courts start taking notice. That's why the Eighth Circuit is leaning toward settlement. That's why even the ATF is signaling they don't have much fight left in this round. So what started as one district court ruling in Texas has now snowballed into a nationwide reset. And that's the kind of chain reaction that shows just how fragile the ATF's position really is when it comes under real judicial scrutiny. Now, let's zoom out and look at the bigger picture, because this fight over braces is just one chapter in a much longer story. If you've been paying attention the last few years, you've already seen how this playbook works. The bump stock ban is a perfect example. The ATF took the definition of machine gun, stretched it until it didn't even resemble the law Congress passed, and overnight tens of thousands of law-abiding owners were turned into criminals. It took years of back and forth in the courts before the Supreme Court finally stepped in and said, enough. By then, most bump stocks were already surrendered, destroyed, or locked away out of fear. The damage was done, and ordinary shooters paid the price. The same story plays out with magazine bans. Look at California's so-called high-capacity ban. For years, gun owners bounced between being legal and illegal depending on which court panel had the case that month. The Ninth Circuit alone has flipped that ruling multiple times, leaving millions of people in limbo. One week, your 30-round mag is just standard gear. The next week, it's contraband. That uncertainty is the real weapon. Regulators know most folks won't risk 10 years in federal prison just to test the waters, so they comply out of fear, even when the rule itself is built on shaky ground. That's exactly what the ATF tried to pull with braces. According to the Congressional Research Service, anywhere from 3 to 7 million pistols with braces are in circulation. That means millions of Americans, veterans, hunters, hobbyists, people with disabilities who actually use braces for stability, were suddenly told they had two choices: register as NFA owners or become felons. Imagine how much power that gives the government. With one rule, they put millions of people at risk of prison time without Congress ever passing a new law. That's why these lawsuits carry so much weight. It's not just about saving a piece of plastic on the back of your AR pistol. It's about drawing a line in the sand and saying, no, an unelected agency doesn't get to rewrite gun law whenever it wants. For gun owners, the takeaway couldn't be clearer. Yes, we've got breathing room right now. The brace rule has been vacated nationwide. The DOJ has walked away from its own appeals. Courts across the country are pushing back. But we cannot treat this as the final word. Until a court squarely rules that pistol braces, and by extension firearms accessories, fall under the protection of the Second Amendment, the door stays cracked open. Another administration could clean up the paperwork, reissue the ban, and put us right back in the crosshairs. So, Celebrate this victory, but keep your eyes open. This is one battle in a war that isn't slowing down. The real question is whether we're willing to keep fighting until the Second Amendment itself, not just procedural slip-ups, becomes the wall that protects us from this kind of overreach once and for all. That's where things stand right now. The ATF's pistol brace rule is on the ropes. The courts are pushing back, and the Trump DOJ has made it clear they're not going to waste time defending it. But like I said, this fight isn't over. The victories we've seen are huge, but they're built on shaky ground, and the next administration could try to run this same play again. As gun owners, the only way we stay ahead is by paying attention, staying informed, and holding the line every single time these agencies overstep. I'll keep you posted as soon as there are more updates, because this story is still unfolding. Make sure you like, subscribe, and drop a comment down below. Stay sharp.